question I'm often asked after someone is arrested, especially in an assault family violence context, is, can the victim drop the charges? I get asked this question incredibly often, and the answer is unequivocally no. Once the police are called to a domestic disturbance, an arrest has been made, the victim simply does not have the power to call up the police officer who made the arrest, or a detective, or someone from the DA's office requesting that all charges be dropped or dismissed against whomever the charges were filed. After an arrest has been made, simply put, it is entirely out of the victim's hands as to what will happen in court next. This can be a very frustrating proposition. After all, they are the ones usually who made the initial call for the arrest, right? They should have the authority then to dictate what happens to the person for whom they made the complaint, right? Wrong. If a victim persists in trying to get charges dropped against their loved one, DAs go into a reactive mode or into a protective role because they believe the person is being pressured into doing this for some reason. The reasons could vary. Maybe they don't want to see their spouse go to jail. Maybe the spouse is pressuring them to make the call to the DA in hopes that the charges will be dropped and they won't have to go to court, go to trial, be placed on probation, and in some cases, go to jail or prison. Either way, often the DAs go into a reactive or a protective mode to protect the battered spouse. And not only will the charges not be dropped, the case may be prosecuted more vigorously against the individual than if the victim had not tried to drop the charges in the first place. The net of all of this is, simply put, regardless of the type of case, the victim does not have the power or the authority to make the decision to drop or to dismiss any pending charges.